With regard to this particular case, I'd like to reserve 5 minutes for rebuttal. I'm going to be referring to the memorandum opinion authored by Judge Williams in connection with my argument. Specifically, the two parties in this case at the time of trial were 52, that is the wife, and the husband 56. The husband was a plastic surgeon. The wife has a PhD in pharmacy. Husband was actively practicing. Wife was not. However, wife maintained her license and can maintain her continuing education with regard to her license so that she was considered to be, quote, actively licensed and employable at any time she choose if she could find a job. This case involves really an issue about alimony and an issue about one property classification. Property classification is the value of the medical practice of the husband. The alimony, however, is more problematic in the sense that there are a number of subparts with regard to the issue on alimony. The court points out that the threshold issue in any alimony case is a question of need. If you do not have a need, you don't even need to address the question of the ability to pay. However, I'll be the first to admit, Dr. Chase does have the ability to pay. So the issue then becomes, does the wife have a need? And specifically, this case is somewhat troublesome in the sense that nobody asked for rehabilitative alimony. Nobody even inquired about rehabilitative alimony. Sui sponte, the judge made a determination that this is a rehabilitative alimony case. And the interesting thing about that rehabilitation is that she wants to rehabilitate the wife, who has the ability, at least according to our expert, of making up to $140,000 a year, is that she should be rehabilitated to allow her to go to a different school, to the Savannah Art School is what the judge is suggesting, so that she can make less, but be more pleased with what she is doing than she would be as a pharmacist. So my fundamental issue with this case is not the law, one in which it's not that you're obligated to work at the job that you are qualified to do, but if you have the potential to do that job, and you have the potential and or the capacity to do that job, isn't that the amount of income that should be imputed to you? It's essentially, if you're being willfully underemployed, it's analogous to the situation with regard to child support. If you're being willfully underemployed, you're going to, again, get an income adjustment with regard to that in the determination of child support. So what you have in this case, we have someone who says she doesn't want to do pharmacy. There is some lip service given, although there's a sworn interrogatory response in which the wife says their health is excellent. Subsequently, in the trial, she talks about some physical limitations. However, her physician, the person that testified on her behalf, said she was capable of having a job and capable of working. The judge, in this particular instance, did not include that potential for income in the determination of need. So we submit that normally an expert would be, at least insofar as a judge's review of an expert opinion, is entitled to a standard of abuse of discretion if she's able to observe and watch the expert in the delivery and presentation of his testimony. That didn't happen in this case. Both the doctor that was the wife's expert and the psychologist, specifically Bill Ray, testified by deposition. I think we cited the Wells Board case in our brief that says this court does not have to defer to an abuse of discretion standard in the evaluation of that particular witness's testimony, but because you have, quote, a cold record, you, in fact, can make a determination as to that particular witness as to what that opinion is worth, because you're in the same position as the trial court who did not see anything with the presentation of a deposition. This particular judge decided not to adhere or even use Dr. Ray's testimony, where he said working from part-time to full-time, it would be $87,000 to $147,000 on an average for a pharmacist. He also said he had reviewed the physician's deposition, and he saw no reason why she could not become immediately employable, because there was a job shortage, according to him, with regard to the pharmaceutical market, with regard to people that were available to be pharmacists.
Mr. Konvalinka, did the wife present any expert testimony regarding her earning capacity, either as a pharmacist or in this other career that she's interested in
She
arts?
did not.
Okay.
And again, the only testimony we have with regard to that is that she claimed some physical limitation that she was concerned that may impact her health. The doctor that she had called did not. He actually used a cute phrase. He said, motion is lotion. She needs to be active, so motion is lotion, is what he said in his actual deposition. Also, you should note that she is involved in sewing, in string guitar or string banjo, I'm not quite sure which, but again, it is, again, a situation in which she goes to the gym 4 days a week. She is very active as far as that goes. The issue in this case is there's a suggestion that our client never asked her to go back to work. There's a disagreement about that in the record, in the sense that our client said he did and she did not. But the other more interesting thing is, if she's going to become rehabilitated and do something else and make, according to Judge Williams, somewhere between $30,000 and $50,000, she has the right to do that. But at the same time, that isn't the issue. The issue here is, what was she capable of doing?
Do we know where the $30,000 to $50,000 came from? Was that the wife's own testimony, own estimate?
No.
Okay. It's just
Bluntly, that's out of the air. And so let's talk about the next issue. So that's one issue about the need. The other part about the need is there's an award of approximately $2 million in assets. There's testimony from Shannon Farr with regard, who is an expert on behalf of the husband, that assuming that she used one calculation at 5%, she used one calculation at 6%, that she would have more than sufficient money, over $100,000 in each instance, to add to whatever, if she really did have a job at $30,000 to $50,000, that would be more than what her need was. And so, again, we submit that there are enough assets on hand, when there's plenty of case law that supports that, in the sense that if you have the ability to make an income off of that, that it accomplishes your lifestyle, then you should not have a need. The other thing that's not addressed, and I'm just using the number of 11,000, which is approximately what the judge did, which was for the need. It includes $1,638 of attorney's fees, as well as other expenses, and I've run out of time, and I apologize for overstepping.
No problem. You have your rebuttal time left. Thank you. Ms. Framer?
Good afternoon, Your Honors. I am Glenna Raymer of the Hamilton County Bar. I am here representing Debbie Chase today. And I'd like to tell you that I'm happy to be here, but I'm not the least bit happy. But I will struggle through regardless of my happiness or lack thereof.
We'll try to make it as comfortable as possible for you.
Thank you. And any questions that you might have, I would like for this to be as collaborative as possible. First of all, Mr. Convalinka neglects to tell you that in this case, there's a 20-year hiatus in Debbie Chase's work-related history. The history of the marriage is this. Even before the parties married, she obtained her pharmacy degree and was working as full-time as a pharmacist. There was a period of time where both parties admit that Mrs. Chase was earning more than Dr. Chase was during the period of residency. Nevertheless, she continued working and contributing her income to the family till. During this period of time, Dr. Chase was well aware that she hated, that she did not do well in the pharmaceutical setting. There's testimony, and I'm derided in the reply brief for mentioning the fact that he massaged her hands. But he did massage her hands. During this period of time, he was very kind to her. He understood that she did not like the practice of pharmacy. He also testified, Your Honors, that she became very stressed and depressed during that period of time. He characterizes it as situational depression. But he knew that she did not like the practice of pharmacy. Not only did she not like it, but the conversations were going on between the two of them constantly, where he promised her over and over again that if she would just hang in there, if she would just work with him during this period of his life, that is until he completed his residency, that she could be a stay-at-home mother. He knew that she wanted to be a stay-at-home mother, and he agreed with that. The record is replete with testimony on his part where he says he acknowledged that it would be better for the children to be at home with her than to be with caretakers that didn't know the children.
And she got to do that. She got to be the stay-at-home mom. I think the question now is, does she continue to get to be the stay-at-home mom when they're divorced and the kids are grown? Because really that's kind of what she's getting, is the same lifestyle that she had while the parties were married. And I think the underemployment question is an interesting one, because if the shoe were on the other foot and we were looking to your client for spousal support, would she be allowed to say, even though I'm trained as a pharmacist and I can go and make 100 to 140, I don't like it and I don't want to? Like, would that fly if it were her being asked to pay spousal support?
After 20 years, respectfully, I'm submitting that no, it wouldn't. You know, first of all, there are no questions, there's no evidence in this record. Never was her expert asked any questions about the technological changes that would have occurred in 20 years in the practice of pharmacy. So I think your point is well made that, you know, if the roles were reversed, what would we expect of a man in the same situation? What we would expect of a man is very different than what happened in this case. In this case, there's absolutely no evidence. What I mean by that is there's no evidence here that anybody addressed the technological changes. There's no evidence in this case that anybody considered her personality with regard to her ability to continue practicing pharmacy. Her expert did two things, really. He considered the evidence that was sent to him by Dr. Chase's attorney, Jenny Lawrence, and he did some research online. But never, ever did he meet Debbie Chase in person. He never called her in. There was never a request, and there's record, there was never a request that she be interviewed by him. So there's no evidence whatsoever that she is, at this point in her life, well-suited to the practice of pharmacy. Not only that, but Dr. Chase knew, as a result of the 20-year hiatus and her contributions to the family life and to the repurposing of the household, all the things that she did, the sewing, the knitting, he knew and understood that she did not have any plans to return to pharmacy. I don't think anybody thought that she would return to the practice of pharmacy.
And which, I mean, ultimately, you kind of get down to the question of what is your responsibility, I guess, when life throws you lemons? Because she's been given some lemons here, being that they're divorcing and he was the breadwinner and a substantial breadwinner. And so what does she do now with her life? What are her legal responsibilities in terms of earning an income versus his responsibilities in paying her?
Okay, and I think those are all good points. What is her legal responsibility in this situation? Let me turn that a bit and say, what is the reason why we would treat her differently than we treat him? You know, he has an earning capacity at this point that eclipses $1 million a year. You know, that's the part that Mr. Convalinka doesn't want to talk about, obviously. You know, what the alimony award in this case is between 9 and 10% of his gross annual income. So he has a tremendous earning capacity. And the assets in this case were rather enviable, but Debbie Chase agreed that Dr. Chase could have all of his real estate. Whatever it was that he wanted, he got, as long as there was an equal division. So why are we treating the two of them differently? Why are we saying of her, you have to return to work and work at your maximum capacity, use your income and your assets to support yourself, but we're not going to do the same for him? You know, he is going to leave this marriage with the same in assets that she will. He is going to leave this marriage with all of his real estate intact, and according to his expense listing, his ability to maintain all of the properties that he was awarded. But we're treating her differently. We're, you know, according to Mr. Convalinka, she should be required to invade her retirement accounts. Why can't she keep her retirement accounts? What's the justification for treating her differently than we treat him? And the judge, you know, did assign some earning capacity to her. The judge did not fully fund her need. You know, in this case, we're really talking about, I think, the standard of review here for an abuse of discretion is that unless it's clearly erroneous, if there's some justification in the record, that in other words, the record has to be construed in favor of upholding the trial court judge's exercise of discretion. And in this case, she exercised that discretion appropriately. She found you know, ironically, Dr. Chase makes the argument in his appellate brief that, you know, it should have been transitional alimony. I think in this case that the trial court judge was actually trying to help Dr. Chase by making it periodic alimony and rehabilitative alimony. By making it alimony in futuro or periodic alimony, obviously he could return to court at his retirement or at any point. You know, she didn't know. This case was tried during the height of the pandemic. And so we didn't know at that point what was going to happen to his income. We knew what had happened during 2020. We knew that even while the city of Chattanooga was shut down, he was able to see people in his office. And so there was a backlog. So we know that he did fine then. But by keeping it as periodic alimony, he can return to court if his income doesn't rebound to $1 million or whatever it was pre-pandemic. It was actually slightly in excess of $1 million a year. So in this case, I'm just asking this court to uphold the exercise of discretion by the trial court judge. She exercised her discretion appropriately. Recently, I tried a case, if you'll bear with me for a minute, I tried a case where the income was about the same during the year of trial. And the trial court judge in that case awarded $13,000 a month alimony. So I think in this case, the trial court judge actually exercised her discretion at the lower range, at the lower end of the alimony issue. If you look at Debbie Chase's income statement, she didn't fully meet her need. She, and I don't want to run over, she actually exercised her discretion to make Debbie Chase responsible for meeting part of her own needs. So whether she likes it or not, she may have to dip into those retirement accounts at some point. But in this case, all of the issues raised by Dr. Chase on appeal, and there are 3 of them, they're all governed by the same standard of review, respectfully, I think. I'm right about that. They're all governed by the standard of review which applies in a case where the trial court judge is exercising his or her discretion. And it's my belief that this record supports the exercise of her discretion on all of the issues. I think she did a fabulous job in this case. And of course, what Dr. Chase is not appealing, what he is not appealing are her decisions with regard to the fair market value of the properties. You know, he's picking and choosing the particular issues, which is his right to do. I understand that. But the point is, this was a well-balanced and well-thought-out decision. And Debbie Chase lost big on the value of his professional office building. The trial court judge found that to be worth $725,000. Debbie Chase's real estate appraiser said it was worth $895,000. So, you know, in this particular case, the judge endeavored to the very best of her ability to strike appropriately. She really attempted to be as fair as she could with regard to each valuation issue. She calibrated the evidence very carefully in favor of both parties. Are there any questions?
I hear none. Thank you very much.
Thank you.
What you're being asked to do is essentially what the lower court did, which is ignore the law. The law is you have to demonstrate a need in connection with this matter. That has not been done. You cannot, to make a comparison to Dr. Chase and his ability to make an income, you ignore her ability to make an income. They're asking you, we don't have to do anything. We don't have to make an income. You just need to decide that this is a judge's abuse, not an abuse of the judge's discretion. With all due respect, it was a wrongful and improper and inappropriate determination of need. If you look at the judge's decision, she doesn't have a basis for the 30 to 50. She ignored the expert report of Shannon Farr. She ignored the expert report of Bill Ray. To say that Bill Ray didn't take into consideration the 20-year hiatus is just wrong. Ms. Raymer asked him the question on page 18 of his deposition, where she says, question, likewise, I see no indication in your report or in your testimony that you considered her 20-year hiatus from this type of employment. Answer, I did consider hiatus. She has continued to maintain her license and is a pharmacist in good standing for the state of Tennessee. Again, he goes on to say there are jobs available to her. The reason, I can't help but go to, for example, the asset valuations, if that's what we want to talk about just for a sec, because that's one of my issues in connection with medical practice. This court knows he's a single-member LLC. He has 8 full-time employees and approximately 3 to 4 part-time employees. None of them are physicians. Some of them are medical assistants. One's a nurse practitioner. Shannon Farr, who's been practicing more than 25 years, and Mike Costello are the 2 experts that testified in connection with this case. Shannon Farr obviously testified on behalf of the husband. I mentioned that earlier. Mike Costello testified on behalf of the wife. They both followed Blasingame, in fairness. They both decided to disregard the transactions between the 2 physicians that had left the practice that Dr. Chase had purchased their interest when they left, each for $50,000. The Shannon Farr used the asset approach. Mike Costello did use the asset approach. They had different numbers for the assets approach. They also did an income approach using the capitalization growth method, each with a different EBITDA number, which I'm not quite sure how you do that, but each with a different EBITDA number, and made a determination as to what the value of the practice was. Shannon Farr appropriately said, look, I have to give weight to the asset approach of 90%. I'll give 10% weight to the capitalization growth. And why? Why did she say I have to give weight to the 90% growth? She explained that. There is not supposed to be a component of goodwill of Dr. Chase in connection with the valuation. That was ignored. The number picked by the judge was way higher than the asset valuation that even Mike Costello came up with. And so what we have a situation in which she has used his high number of $300,000 and picked a random number of 255, just like she did a random number in connection with the income. You have to at least follow the law with regard to this. The law says you don't impose a goodwill component in the valuation of that asset. Yes, I picked that as an issue. I did pick it as an issue because that was an issue that was wrong. Just like I picked the issue with regard to alimony because it's wrong. You've got a man who's facing a alimony and futuro situation that with a person that doesn't have a need. You have rehabilitative alimony. I'm not sure how you can have rehabilitative alimony when you already have someone who's fairly well qualified to do a job. And there's been no demonstration she cannot do the job except that she does not like it. But at the same time, we have no indication that she's really done anything to rehabilitate herself otherwise. The judge even recognizes that in her memorandum of opinion. She says she's not done anything. Divorce opinion over a year. So again, with all due respect, there has been an improper decision made that should be corrected. Thank you. I've run out of time. I apologize.
Thank you very much, Mr. Cumberland. I want to thank both of the attorneys for your presentation in this case. Your case has now been submitted to this court. You should receive our opinion within a reasonable period of time. Thank you both, and the lawyers may be excused.